Hello, I would like to talk about my experiences growing up with sports cards. So, as a kid, I would always collect baseball cards, basketball cards, football cards, you name it, I collected them. But there's times growing up where me and my friends, we'd always want to trade because somebody would always have a better card. A more expensive card, more valuable. So, one day I traded my friend Reagan for a Bobby Knight basketball card. That card was pretty valuable, so I ended up giving him 3 of my high-priced cards. Once I got the card, I immediately put it into a casing to preserve it because any good card collector or card seller knows that any harm to the card will lose the value of the card. And therefore, it's just not worth the price it was at one time. Now, I would like to talk about this case regarding sports cards. Through research, we have learned that the overall event of this is one man named James Fitl purchased a baseball card from a card dealer named Mark Strek. The card that was purchased was a Mickey Mantle Topps card. Fitl purchased this card for $17,750. To keep it safe, he immediately put it into a safe deposit box for 2 years. After the 2 years was up, he got the card out and got it appraised just to make sure that the value had increased. At the appraisal, he found that the card was not authentic and had been trimmed and therefore was valueless. Upon this finding, Fitl sued Strek, saying that he relied on his stance as a professional card dealer and that the card was authentic. Strek answered with, Fitl waited too long to bring the defects up to his knowledge, and it was now too late to bring the card back to the owner before Strek, and that way they could not obtain relief from the previous owner. Strek did not believe he was liable. Another fact was there was no written agreement throughout this case. Issues seem present in this case. The main issue is the card was not authentic, it was trimmed. That way there was no value. Personally, an issue that we thought was Fitl or Strek did not have it appraised before buying or selling it in their own stances. A huge issue was they did not have a written agreement to fall back on in the case that they had to determine liability. Strek was not knowledgeable in this case as a card dealer. And another issue may be Strek most likely had spent the $17,750 that Fitl spent on the card. Therefore, if Strek was to give a refund, a full refund, that money may not even be there and he might not be capable of doing that.
If I were representing James Fitl, the argument that I would suggest is that James Fitl was not given the product that he paid for. In this case, James Fitl went to a sports card show, and Mark Strek showed this card, this Mickey Mantle baseball card, said it was worth $17,750. That's how much he wanted for it, and he stated that it was in near mint condition at that time. And so this was the product that James Fitl was paying for, and he believed he was paying for a near mint condition baseball card. However, this was not the case, as he sent the card to a professional sports card grader 2 years later, and he found out the card had been refinished, trimmed, altered, and in this case, that would make it valueless. And so James Fitl was not given the card that he paid for. And in this case as well, they asked a couple other professional sports cards dealers to ask their opinion on this case. And one of them, Steve Orand, he talks about that the timeline for sports memorabilia is a lifetime. So whatever card you're giving, no matter how long it is after, you are responsible for the condition of the card that it was given at the time, if you are a reputable sports dealer. And so he says in this case, Mark Strek claims to be a reputable sports dealer and thus should return the card because it was not given in the condition that he previously stated. And so I believe James Fitl has a case because he was not given the product that he paid for. But in order to consider this, there's a few questions I would ask James Fitl to make sure he has a case. One question is, did he ever take the card out of the safe deposit box that he had during those 2 years? Because if the card was ever taken out of the safe deposit box, it could have been refinished or trimmed while in his possession, which would make his argument invalid or useless. And another question I would ask him is, was he ever made aware, there was no written contract, but was there any verbal warnings about the card when when Fitl purchased his card from Strek. Did Strek say anything like, this card may be damaged, or you are responsible for whatever condition this card is already in? Because if he said this, even if Fitl was not necessarily paying attention to that, that would put the responsibility on Fitl for the condition of the card. And there's a couple questions I'd like to ask Mark Strek as well. For one, where did he acquire the card? Because if he's being honest and says he has no idea that the card had already been refinished and trimmed and altered while in his possession, then who did he get the card from? Because whoever he got the card from, likely they knew about the altering, or they were the ones that did the altering. And another question is, does he have an authentication process for the cards he sells? Because if he really did not know this card was altered, can he be considered a professional sports dealer in that way? Does he have an authentication process to know that this card has been altered and this card has not? Or else how can you trust him as a professional sports dealer if he does not know which cards are altered or which cards not? Or if he's lying, then he can be considered a reputable dealer in that way as well, because he's selling products that he is being dishonest about. And then has he also had any past problems with this? If he doesn't have that great of an authentication process and he's selling cards that have already been altered, has this happened in the past as well? Because we don't know what kind of authentication process he has, because it does not appear to be accurate in this case.
Hello, my name is Jacob, and the question that I had for the case study was, what other additional information would I want to know as a juror or judge? And two things came up, which one was when the deal was made with the customer and the dealer, was there any sort of waiver or contract ever written contract ever written down saying that the dealer wouldn't be liable if any mistakes or damage was done to after the sale whatsoever? Because then that would not make for the being sued, that would be proof showing that he wasn't been liable with it. So then that would just end it either way, the lawsuit. And the second question was on the dealer side of things, was when he first bought it from the third party to begin with, was there ever sort of thought of fraud or counterfeit of the card or whatever? And just when he, knowing that knowledge and not telling the customer that he resold it to, could have been really bad on his part, and that could persuade a juror or judge in how he decides not giving out that information to begin with.
My name is Melissa, and the question that I answered for our presentation was, what was the court's decisions and remedy at the end of the case? Strek's main defense was that Fitl did not notify him of the damages at a reasonable time. He argued that Fitl should have reported about the card within the typical grace period, which he said was 7 days to 1 month. Fitl explained that he trusted Strek within his position as a professional sports card dealer and locked the card in a safe box for 2 years, which we previously mentioned in this presentation. After those 2 years, that's when Fitl wanted to try to sell the card. So he went and got it appraised, where he learned it was worthless. The Nebraska State Court decided against Strek and allocated Fitl the $17,750 that he used to purchase the card in the first place, and also covered the costs of the court proceedings and stuff. Strek was unhappy with this decision and took it further and appealed it with the Nebraska Supreme Court. Unfortunately for Strek, the Supreme Court also ruled in favor of the lower court. Both courts believed that 2 years was a rational amount of time to report damages given the circumstances of the case. After reviewing the facts, issues, arguments, and questions of the case, our group concluded that we agree with the court's rulings. Strek used his position to participate in fraudulent activity and did not protect himself by creating a formal contract. Fitl responsibly took care of his card under the impression that it was the original, and only discovered it wasn't after getting it appraised. With this understanding, it makes the most sense for Fitl to receive his money back.